On March 6, 2023, the owner of the Master of Puppets YouTube channel, who we will refer to as Mr. Master, entered an immigration checkpoint in Cerrito, Texas. Mr. Master filmed the encounter between himself and the Customs and Border Patrol agents and later posted it to his YouTube channel.
Okay. Oh, wait a minute. Wait a second. Sorry, what was that? By yourself?
Just me, he and I.
All right, United States citizen?
Yep.
Is this your vehicle?
Yeah.
All right, give me a second. Secondary? Okay, dogs learn to your vehicle, so we got to find out why. Is there anything illegal in the vehicle we need to know about?
No.
You smoke weed, nothing like that?
Nope.
Nope? Okay, we got to verify, right? So you see, you're gonna park right in front of that SUV.
No, I don't want to participate.
Well, it doesn't matter. Huh?
Where's the turnaround?
Well, turnaround's right there, but you cross here, that's it.
Well, I'm not going to cross here then.
Well, it doesn't matter. You're already here.
Yeah, I'm not participating.
It doesn't. Sir, authority allows us to check your vehicle with a canine alert. So you're going to pull over right here.
No, that's all right. You can do it here.
Huh?
If you're going to go around the car, just do it here.
Why? Is there something illegal in the vehicle you don't know about?
No, I'm not. I don't do anything.
All right, sir. This is an immigration checkpoint. Canine alert to your vehicle. You got to verify what's in this vehicle. Okay? So you're going to pull over right here, this vehicle right here, behind this.
The Border Patrol agent argues that they need to search the vehicle because the canine alerted to it at an immigration checkpoint. We will discuss the legality of the agent's attempt to search Mr. Master's vehicle later in the episode, but for now, it is important to note that the officers were likely within their constitutional authority to circle the vehicle with a canine while Mr. Master was lawfully detained at the checkpoint. In the 1983 case of United States versus Place, the Supreme Court ruled that exposing an individual's luggage to a canine sniff in a public place, quote, did not constitute a search within the meaning of the Fourth Amendment, reasoning that a dog sniff is, now quoting again, much less intrusive than a typical search because it doesn't require opening the luggage or revealing non-contraband items hidden from public view. Similarly, in the 2005 case of Illinois versus Cabayas, the Supreme Court reasoned that using a proficient narcotics detection dog that avoids revealing non-contraband items hidden from public view during a lawful traffic stop typically does not raise concerns about valid privacy interests because when a dog sniff is performed on the exterior of a vehicle, now quoting, any intrusion on privacy expectations does not rise to the level of a constitutionally cognizable infringement. Consequently, the court concluded that, quote, a dog sniff conducted during a lawful traffic stop that reveals no information other than the location of a substance that no individual has any right to possess does not violate the Fourth Amendment. Although the court also noted that a seizure can become unconstitutional if it is unreasonably prolonged to conduct a sniff. In addition to these dog sniff decisions, the Supreme Court has upheld the authority of Border Patrol to operate checkpoints to question individuals about their citizenship and make plain view observations of the interior of the vehicle. In the 1976 case of United States versus Martinez Fuerte, the Supreme Court ruled that the government's interest in preventing illegal immigration outweighed the minimal intrusion on motorists detained at reasonably located checkpoints, even when lacking reasonable or individualized suspicion. Furthermore, the court held that it is constitutional to refer motorists to secondary inspection areas with, quote-unquote, no particularized reason because the intrusion is sufficiently minimal. And, now quoting again, Border Patrol officers must have wide discretion in selecting the motorists to be diverted for the brief questioning involved. Citing both the Place and Martinez Fuerte cases, the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, upheld a canine sniff of a vehicle at an immigration checkpoint in the 1990 case of U.S. versus Davali Avila, concluding that, quote, a dog sniff does not constitute a search, whether it occurs at the primary checkpoint or at the secondary checkpoint. Similarly, in the 2003 case of U.S. versus Garcia, the Fifth Circuit determined that, quote, where Border Patrol agents wish to employ a drug-sniffing dog at an immigration stop, they may do so if it does not lengthen the stop beyond the time necessary to verify the immigration status of the vehicle's passengers. Accordingly, a court would likely conclude that the Border Patrol agents had the authority to conduct a canine sniff because Mr. Master was lawfully seized at a legal immigration checkpoint. And as the dog allegedly alerted very quickly after Mr. Master was detained, the sniff did not prolong the stop.
Are we going to go?
No, you're not.
Am I free to go?
No, you're not. You're not going to leave here until you get secondary. Oh, you just want to
Yeah, we got stopped at the immigration checkpoint. They won't let me turn around. They won't let me go. Or the dog alerted to something on the car. I don't know.
I understand. Are you explaining it?
No, sir. Do you understand what's going on, right? You don't understand what's going on? What's going on? The dog alert to the vehicle. Once the dog alert to the vehicle, that gives us probable cause to search the vehicle. We are asking you you understand what I'm saying? You have to pull the cycle. You're obstructing traffic.
Well, I want to just keep going.
You're not going to be allowed. You're formally detained.
Before we continue the interaction, I want to give a big thanks to the sponsor of this episode, Dude Wipes. Sometimes you just have to face the facts. Santa's not the only one dropping packages this year. The difference is that Santa gets to disappear up the chimney when he's done, and the rest of us have to handle our own cleanup. And that's where today's sponsor, Dude Wipes, comes in. The holidays are chaotic enough without adding a bathroom disaster to your to-do list, so make your jingle smell jolly with Dude Wipes Dingle Bells, the festive way to keep your cheeks merry and bright. For those times when you deck the bowls instead of the halls, Dude Wipes have your back. Literally. No skid marks, no dingleberries, no post-potluck catastrophes, just clean confidence. Because let's be honest, dry toilet paper doesn't clean. It just smears. You wouldn't take a shower with a dry loofah, so why would you trust dry paper to finish the job? These bad boys are extra large, extra wet, and built to handle business like a champ. And they don't stop at just keeping things clean. They do it in style, with options like mint chill, shea butter, and even the limited edition Dingle Bells for those who want a little extra holiday spirit where it counts. Whether you're at home, on the road, or working through a day that's been one long sleigh ride from hell, Dude Wipes has a pack for every situation. And before you ask, yes, they're flushable, made from 100% plant-based natural fibers, and manufactured right here in the USA, so you can wipe with confidence, knowing you're not just cleaning up your act, you're doing it responsibly. So this holiday season, keep your sleigh clean, your confidence high, and your bathroom routine legendary. Stock up your sleigh with Dude Wipes, available on Amazon and retailers nationwide, or you can just click on my link below. Dude Wipes. Bigger, wetter, better, and made for us. Thanks again to Dude Wipes for sponsoring today's episode.
Okay, for what?
The dog alerted to the vehicle.
For what?
I don't know.
So you suspect me of what?
All we need to do is get you out of the vehicle so the dog alerted to the vehicle. We don't know why the dog alerted to the vehicle. We need to get you and the dog out of the vehicle so the dog can come run the vehicle and find out what it's alerting to. If it's nothing, you'll be down the way. But
No, thank
can
you.
you just park to the side right there?
The agents inform Mr. Master that he is being detained because the canine alerted, arguing that this gives them probable cause to search the vehicle. In the 1985 case of U.S. versus Montoya de Hernandez, the Supreme Court emphasized that Congress has always granted the, now quoting, authority to conduct routine searches and seizures at the border without probable cause or a warrant in order to regulate the collection of duties and to prevent the introduction of contraband into this country. However, in the 1975 case of U.S. versus Ortiz, the Supreme Court established that the Fourth Amendment prevents Border Patrol officers from conducting warrantless, suspicionless searches of private vehicles when the stop or checkpoint is removed from the border or its functional equivalent. Accordingly, agents at the Cerrito, Texas checkpoint would need probable cause to search a vehicle without a warrant due to the location of the checkpoint, which is not situated on the U.S.-Mexico border. In this situation, the Border Patrol agents claim to have probable cause to search Mr. Master's vehicle based on the dog's alert. In the Dovali Avila case, which we discussed earlier in this episode, the Fifth Circuit determined that in the context of an immigration checkpoint, quote, a dog alert is sufficient to create probable cause to conduct a warrantless vehicle search. In reaching this conclusion, the court noted that, quote, dogs assigned to work with Border Patrol agents are specially trained to detect concealed contraband or hidden people in the vehicles that pass through such checkpoints. The dogs are trained to alert, take a particular position or stance, only when they detect such contraband or people. When a dog so trained alerts in the near presence of a particular vehicle, that action is sufficient to give rise to probable cause to search that vehicle. Although the dog that sniffed Mr. Master's vehicle was apparently trained to detect both drugs and humans, it is important to note that courts have also allowed warrantless vehicle searches at Border Patrol checkpoints based on alerts from dogs that are not trained to detect smuggled individuals, despite the lack of an immigration-related purpose. For instance, in the Garcia case we mentioned earlier in this episode, the Fifth Circuit concluded that the sniff alert from a quote-unquote drug-sniffing dog provided probable cause to search a vehicle, with no mention of the dog being trained to detect humans as well. However, it's important to note that a court may conclude after the fact that a dog alert did not provide probable cause for a search if the dog is found to be unreliable or the circumstances surrounding a particular alert call the probative value of the alert into question. As the Supreme Court recognized in the 2013 case of Florida versus Harris, quote, if a bona fide organization has certified a dog after testing his reliability in a controlled setting, a court can presume that the dog's alert provides provides probable cause to search. A defendant, however, must have an opportunity to challenge such evidence of a dog's reliability. And, even assuming a dog is generally reliable, circumstances surrounding a particular alert may undermine the case for probable cause. If, say, the officer cued the dog, consciously or not, or if the team was working under unfamiliar conditions. Therefore, while the officers likely had arguable probable cause to search the vehicle based on the dog's alert, it is possible that a court could conclude that probable cause for the search did not exist if the evidence showed that the alert or the circumstances surrounding it were insufficient to provide it.
Hey, he's coming out over there. No.
So what do you guys suspect me of doing?
Sir, nothing. We just got to figure out why the dog alerted.
So you suspect me of nothing?
So we need to find out
what does that
why
mean?
the dog is alerting. The dog is alerting.
The dog's alert to either contraband or hidden person.
Well, I don't have any of those things in here.
Okay, I understand that.
Well, I'm not going to consent to a search of my vehicle.
Okay, sir, the dog alerted vehicle, you're going to get out of the vehicle either willingly or we're going to take you out of the vehicle, and we are recording. And everything we're doing is legal. You want to go over there in the secondary. We ain't got all day. You're holding up traffic.
I'm not holding up the traffic. You guys are.
Okay,
I'm detained, right? You said I'm detained?
Okay.
I want to go.
No, you're not going to go.
Okay.
You are detained?
Yeah, I see.
You're detained because the canine alert, which gives us probable cause to search the vehicle. You understand that?
No.
Okay. All right. I'm going to give you the option to come out of the vehicle on your own, or you can pull it over there and we can continue that discussion. I would prefer that you pull it over there so we can finish this discussion. Because at the moment,
Well, if I'm detained, I guess I can't move, right?
No. You can move over to the secondary inspection area, okay?
No, thank you.
This isn't an option.
Okay. So, I can't go forward, and you want me to go over there. I don't want to go over there.
I understand that you don't want to go over there, but we have probable cause to search the vehicle. See where it says it right there, right? Our checkpoint authority?
No, you keep interrupting me. I'm trying to read it.
Okay. Well, you can read it over there. But for now, I need you to get out of the road. You're impeding traffic. If you do not do that...
I'm not impeding traffic.
You are. You're holding up the traffic.
I'm trying to go that way.
Right. And you cannot go that way.
Could I turn around?
No, but you can pull over here and we can continue that discussion.
Well, no, thank you.
Okay. All right.
Are you saying I got to step out of the vehicle, right? That's what you're saying? Okay, is that...
No, I just need you to get this...
If I refuse to step out of the vehicle, are you going to arrest me?
So you're being detained, right?
Okay, I'm being detained.
Okay, so let me...
If I refuse to step out of the vehicle, are you going to arrest me?
No, we're going to detain you.
Okay. That's a no, right?
No, if you refuse to get out of the vehicle, we're going to make you get out of the vehicle. We will physically remove you from the vehicle.
So that's an arrest?
It's not an arrest. You're being detained. We can figure out why the dog's alerted. Sure, but
how are you going to remove me from the vehicle if it's not an arrest?
We will have to force it. I don't want to do that.
So you're going to use violence with no law?
No, we have a law. We have probable cause.
To remove me from the vehicle with no crime? Under threat of arrest, I will get out of the vehicle.
Perfect. But for right now, just pull over to the secondary inspection area so we can get these vehicles and not cause an accident. You understand? So for right now, just go over there. We can continue talking, but I just need you to go over there and get out of the road. Okay? Perfect.
Is that an order?
Yes.
If I don't move over there, you're going to arrest me?
Yes. All right.
The agents inform Mr. Master that they will physically remove him if he refuses to get out of the vehicle. As we have discussed many times here on ATA, the Supreme Court held in the infamous Mims case that officers may, as a matter of course, order individuals to exit vehicles during a lawful detention. To this end, courts have also held that because law enforcement officials have the authority to order individuals from vehicles, they may use reasonable, forcible means to enforce this lawful order. For instance, in the 2009 case of DeVille versus Marcantel, the Fifth Circuit Court of Appeals acknowledged that, quote, officers may consider a suspect's refusal to comply with instructions during a traffic stop in assessing whether physical force is needed to effectuate the suspect's compliance, but ultimately concluded that, in the case at hand, a reasonable jury could conclude that the force employed was excessive when the driver's refusal to exit the vehicle constituted purely passive resistance, and the officer engaged in, now quoting, very little, if any, negotiation with her, and that he instead quickly resorted to breaking her driver's side window and dragging her out of the vehicle. Now, while the vast majority of cases involving officers using or threatening force to remove non-compliant drivers from vehicles occurs during traffic stops, it seems likely that courts would adopt similar reasoning for lawful detentions at immigration checkpoints. Additionally, in the Customs and Border Patrol Manual on the use of force, the policy states that agents may use, now quoting, objectively reasonable force only when it is necessary to carry out their law enforcement duties. And the reasonableness of a particular use of force is, now quoting again, based on the totality of circumstances known by the agent at the time of the use of force, and weighs the actions of the agent against the rights of the subject in light of the circumstances surrounding the event. Accordingly, a court would likely conclude that if Mr. Master had continued to refuse to exit the vehicle or comply with the order to move to the secondary inspection area, the officers would have been within their authority to use reasonable and controlled force to remove him from the vehicle, as they had already engaged in a fair amount of negotiation and informed him that he could be subject to force if he continued to refuse to comply.
Looking for goddamn Mexicans. Why? The good people.
Now that you're not impeding traffic,
Gotta get my drugs.
yeah, you can't smoke in the secondary area.
Okay, I'm gonna smoke in the car then.
If you want to take your dog with you, if you don't have anything, if you have nothing illegal in the vehicle, you'll be on your way in no time. Which door do you want to come out of? You're going out the side door. You're going to want to grab your dog with you. Are there any weapons in the vehicle?
I don't have
You can't. Okay. All right. Going out the side door.
So I want to make sure I got your name.
My name is Border Patrol Supervisory Border Patrol Agent Jimenez.
Jimenez?
Okay.
Let's see, we got a Santiago.
Yes, sir. And you're done.
Yes.
Keep going.
Sir,
All right, I just want to make sure I get everybody's.
Sir, this
This is federal property.
Yes. Hello.
All right, sir. I'm gonna have you. You're gonna need to move your vehicle now.
Yeah, we're in federal property, which is the same as saying it's public property, publicly owned property.
No, it's not.
It's the side of a road, isn't
It's
it?
an enforcement area. Okay. So I'm gonna have you.
Yes, it's a. Why are you touching me?
Because I'm escorting you to your vehicle.
Don't escort me. I gotta get your names.
You got my name.
I gotta get your
If
names.
you don't leave now, county will cite you. You understand?
For parking on the side of the road when you're detaining me.
You're not detained any longer.
Have a good night.
You guys.
After the Border Patrol agents searched the vehicle and found nothing, they released Mr. Master and he left the area. Very little information is available about the encounter, and it is unknown whether Mr. Master filed a complaint or intends to pursue legal action. Overall, the Border Patrol agents get an A-, because although they could have explained the law more clearly at times, they likely remained within their lawful authority throughout the encounter and engaged in extended verbal negotiations to obtain compliance from Mr. Master rather than resort to force. However, there are always limitations on my ability to issue truly accurate grades, and as the footage does not show the dog alerting, it is feasible that there could be some fabrication or other malfeasance involved, particularly given the fact that the agents did not find any contraband in Mr. Master's vehicle. It is also possible that a court could determine that the dog alert did not amount to probable cause based on issues with the dog's training or reliability, if an agent prompted the dog to alert, or some other unknown fact about the circumstances surrounding the alert. For instance, in a 2015 publication regarding potential civil rights abuses in the Border Patrol's interior enforcement operation, which I've linked in the description down below, the ACLU alleged that citizens regularly complain of false canine alerts at immigration checkpoints, and that the Border Patrol does not track false alerts or require continuing canine certification based on field performance. Still, based on the information available to me regarding this specific encounter, the agents appeared to be complying with the Constitution, and I have no reason to believe that these agents were involved in any sort of misconduct besides the general trends involving false alerts at immigration checkpoints. Mr. Master gets a C for refusing to comply with lawful orders from the Border Patrol agents, delaying other motorists by failing to move to the secondary screening area, and demonstrating a substantial misunderstanding of the law surrounding dog sniffs and the authority granted to Border Patrol agents at immigration checkpoints. Now, although I commend Mr. Master for maintaining a calm and respectful demeanor throughout and attempting to enforce his constitutional rights, a court would likely conclude that the agents were within their constitutional authority to search his vehicle based on the dog's alert, and to threaten to physically remove him from the vehicle if he refused to comply. Now, while Mr. Master is certainly within his rights to disagree with the way courts have interpreted these contours of the Fourth Amendment, citizens are required to comply with the law as it currently stands, or potentially face legal consequences. And I encourage Mr. Master to learn more about the powers granted to and the limitations placed on Border Patrol agents at immigration checkpoints if he will regularly encounter them during his travels. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.